Studies. It is my pleasure to open this symposium. This symposium will begin this morning, last all day, dinner this evening, all day tomorrow, dinner tomorrow, and Sunday morning, a program on Nuremberg and film. Will be finished by noon on Sunday. We are celebrating commemorating the 60th anniversary of the judgment at Nuremberg. The judges began reading their judgment on September the 30th, 1946, and ended the following day, October 1st. And this is their 60th anniversary. A program like this would not be possible without a great deal of effort. Doing the logistics that have made everything for the next 2 days and a half possible was Linda McLean, the Assistant Director of the Harris Institute. And Linda, where are you? The substance of this program, as many, if not all of you know, was arranged by Larry May and Layla Sadat. Larry May of the Department of Philosophy and Layla Sadat here in Boston. They have been tireless in their energy and effort in putting this together. Without them, this program could not have been possible. They have been working at this for over a year. You will hear, they will be making some remarks in just a few minutes. The third ingredient to a successful program, and certainly one as ambitious as this, is support, financial support. And without the financial support of the law school, both through the Institute as well as directly, this program could not have been possible. Nor could it have been possible without the generous support from the Department of Philosophy. Representing both Mark Rollins, the chair of the Department of Philosophy here at Washington University, and taking the dean's place, Ken Severin, unfortunately, his plane was canceled. He was coming in this morning from Washington, D.C. Very appropriately, is our vice dean, and the person who was dean when this program, the planning began, Dan Keating. And I'd like to turn the program over to Mark and Dan for some welcoming remarks. Thank you very much.
Cherif Bassiouni, I think, is much more than a professional scholar and activist. You can read his very distinguished resume in your materials. He has really, for many years, been at the heart and soul of the movement to establish a permanent international criminal court and many other mechanisms to bring justice to those who have suffered from the commission of atrocities. He has himself suffered from the fear of torture and from unlawful imprisonment. He has been literally in war zones, both in the former Yugoslavia, in Iraq, in Afghanistan. He has dedicated himself really to bettering the world for others. After escaping from Egypt in 1962, he spent his time in the United States as a professor at DePaul College of Law, teaching classes, doing pro bono work, and specializing particularly in international criminal law and human rights. He was the chair of the drafting committee for the diplomatic conference that adopted finally the International Criminal Court Treaty in the summer of 1998, and I had the privilege at that time to sit at his elbow and watch some of the extraordinary work. And I have to say that they worked unbelievable numbers of hours. And in his spare time, when he was taking breaks, he was writing the second edition of the Crimes Against Humanity treatise that I had relied on in my work in 1996. He was ultimately nominated for the Nobel Peace Prize for his extraordinary work and vision in the field, and I hope someday he ultimately receives that, as well as the International Association of Penal Law, because the International Criminal Court Treaty, I think, would not have been achieved without him and, of course, many others. Ladies and gentlemen, it is my pleasure to give you Professor Cherif Bassiouni, a man of great vision, extraordinary intellect, and astonishing achievement, and a dear friend and colleague. Thank you, Cherif.
It's a great honor and privilege to be here with you at this conference. And as I was looking at the audience, a thought came to my mind, which I draw in part from my military three succeeding waves of combatants in the field of international criminal justice in this group. The first wave that landed, Whitney Harris, Ben Ferencz, Henry King, here represented. A few of us are of the generation of the second wave, and many are here part of the third wave. So irrespective of ages, Ben was in the first wave, but he was a very young man at the time, and there may be those in the third wave who may not be as young, but the significant factor is that it's wave after wave after wave, and I suspect there will be many more waves and consisting of many more people of all different generations and cultures who will land on the beaches fighting for international criminal justice. As I was approaching this task, I didn't really know how to approach it in light of the extraordinary diverse experiences of so many of you, both in the fields of philosophy, social science, law, history, and I would suspect that maybe we should have had some social psychologists and psychologists to also take a look into the legacy of Nuremberg and its evolution. And I don't really know why, but I will share that with you. I suddenly, what came to my mind as a sort of a free mental association, is a poem by Victor Hugo in French that deals with the Battle of Waterloo. And of course, there's no analogy between a defeat and a victory, as in this case is. But it came to my mind because that piece of poetry started in an extraordinarily evocative way. It started by repeating the word Waterloo, Waterloo, Waterloo. And anyone who would hear the poem, or read it, would suddenly find themselves emotionally transfixed by the words and the repetition of the words. And I wondered, what is there in a word that can mean something for so many people and for such a long period of time? I mean, what is it in the word Nuremberg, 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 Norimberga? And I thought to myself, well, the difference varies enormously. As I traveled for almost 2 years, crisscrossing Afghanistan, there is no doubt that it's a word that absolutely no echo. It didn't resonate in the minds of anybody, and it meant very little. As I crisscrossed Iraq for the last 3 years, I found almost the same, even though there were many more people in Iraq who knew of the historic fact, but it really didn't mean much to them. And so we can immediately see, if I can use the term, the cultural relativism of the meaning of a legacy. But the historic impact and legacy of institutions are not only subject to wide-ranging collective and individual perceptions, they are also a matter of how we evaluate or assess an a priori experience with relationship to its a posteriori impact. Among the different factors that one can think about is what is the method that one would employ in order to make an assessment. And here I was sort of stopped immediately by trying to relive some of my own experiences. And in that, I thought of people like Jackson and Taylor and Harris and Henry Ben and others. And I thought to myself, well, let's start from the beginning. I walked into war-torn areas, and I imagined they came into Nuremberg. The city was probably quite destroyed, if not entirely destroyed, with very few buildings in place. They were largely dependent upon going on an army military truck to go to maybe a hotel that was still halfway in a position of hosting them. Very few people looking back in terms of a historical assessment keep in mind the context, the environmental factors, the personal factors that impact on the person who arrives at the scene of a war or a war-torn city. Unless you arrive in a convoy, you arrive by yourself. You're accompanied by a driver who takes you on, military escort, very impersonal. You're really very much by yourself. You're very much alone. A substantial portion of your thoughts involve your personal security, but more so, if I may say so, your personal comfort. Where are you going to sleep? Is it going to be warm? Will you have anything to eat? Simple things, and then the next day you wake up and you say, well, how am I going to do this work? Do I have a secretary? Who's going to type? What if the machine doesn't work? What if the fax machine doesn't work? Or the photocopying machine doesn't work? Or what if the army doesn't send the truck or the car to take me there? How dependent am I going to be on somebody bringing the witness in? And so on, and you suddenly realize that what we as intellectuals 10, 20, 50 years later look back is really unrelated to both the emotions of the moment, the practicalities of the moment, and all of the factors that impact on what you are going to do on that particular day to get things done. I would like to be able to say, for example, after a number of years, that when I decided on doing the rape investigation in the former Yugoslavia, I had it all planned. I had 33 women volunteers, that I knew exactly that each team should be a woman prosecutor with experience in violent crimes, a woman interpreter, and a woman psychiatrist. How was I going to deploy them? How am I going to pay for it? That I had a plan, that I had a scheme, that I knew how it was going to come out, that ultimately there will be people that will be able to take some of these notions of prosecuting victims of rape for war crimes and crimes against humanity, take that data, use it, bring cases into it, and so on and so forth. It doesn't really happen that way. You sort of stumble into things. You do things mostly on a day-by-day basis, and you're significantly conditioned not only by the immediate factors of your context and your environment, but the external factors on which you really have no control. You know, here's a wicked Ralph Zacklin in New York pulling the strings and make it impossible for me to be able to go ahead and do this or that. Are there really senior or major political reasons why this should be done and this shouldn't be done? And yet, somehow, in time, there is an extraordinary way in which, in the same way that time allows human memory to delete the painful experiences and allow us to live with them in a different form, history has the same effect. Remember, if you will, what I would consider to be the absolutely extraordinary failures of post-World War I prosecutions. If anyone would look at the newspapers in France, Belgium, the Netherlands, England, just look at some of the headlines, and think of the idea of Kaiser Wilhelm II, who was presumably the worst ogre in history, being able to evade prosecution of a very specific provision in the treaty, Article 227, to prosecute the Kaiser. How did it happen? And I would like to bring to your attention 3 small details. And I would urge you to think of where do you find those 3 details today as people recall back. How many times in reading about the prosecution of the Kaiser have you stumbled, and I'm sure many of you know that, but how evident it is that the Kaiser was, after all, the grandchild of Queen Victoria, and that his cousin was the Tsar of Russia, and that he was related to all of the monarchies of Europe. I mean, how could anyone ignore the fact that there was no way that England was going to allow the Tsar of Russia to be prosecuted? Because that meant that the next prosecution was going to be the King of England, and that would be totally impossible. But how then can you satisfy the rousing public opinion in France in particular that we must go after the ogre? Well, we have to feed the crowd something. We have to please the crowd. We have to find a way to appease them. And so it was done in a very elegant English manner, I must say. They're not always elegant, but in this case they were extremely elegant. They sent a very astute lawyer from the Foreign Office to draft Article 227. Now, please imagine World War II with the terrible results of an entire generation of Europeans that were wiped out in one of the craziest possible types of war in the world, in which ego of generals prevailed over any good sense or rational military approach of just sending waves after waves of people from one trench to another. The eruption of sentiment of trying to blame somebody, and Kaiser Wilhelm was the person to blame. It would have been so ideal. It's like blaming Saddam Hussein for all of the ills of Iraq, and then maybe after that we can forget about it and move on. So Saddam is the ideal person from whom to hang that on, as was Kaiser Wilhelm. Not to exclude their responsibility or mitigate it in any way. But the point is, how do you accomplish that in the minds of the people? And how do you make sure that in practicality it doesn't happen? Well, it's very simple. The first thing is you have this very astute Foreign Office lawyer who comes and drafts Article 227 and who says the Kaiser is accused, and Whitney picked up from there a few years later, is accused of the supreme crime against the sanctity of treaties. Now, it does sound very good, as frontline newspapers. I mean, the French are satisfied. I mean, imagine finally the Kaiser is going to be prosecuted for the supreme offense against the sanctity of treaties, and all of nations, and all of these beautiful things. And then, of course, he goes to the Netherlands and seeks asylum, and the Dutch government says, what do you want to prosecute him on? Has anybody heard of a crime called the supreme offense against the sanctity of treaties? Of course not. Well, I'm sorry, we have to give him asylum. We can't extradite. And once in a while throughout history, like in Srebrenica recently, the Dutch take the fall. And so, the Dutch said, we will give him asylum, and everybody blamed the Dutch for giving them asylum, just like the Dutch decided not to allow their contingent in Srebrenica to protect the Bosniaks in July of 1995, and then they took the blame. They were accused, and the Dutch know that it's just a question of rolling over time, and then just a few months later, or a few years later, it'll just be another footnote in history. And so the Kaiser avoided all of that. Now, how many read that and understand the significant background of why the Kaiser wasn't prosecuted. But is that really important? By the time Whitney came on the scene and he wanted to prosecute tyranny, he had to find crimes against peace as a viable international crime. Well, was there such a thing, to be perfectly honest? I don't think there was. But we needed it. And so we made it. In fact, I will never forget a debate going on during the discussions in London on the Charter, where André Gros, representing France, says, but there is no such thing as a crime against peace or aggression. And Maxwell Fyfe says, there is because we say there is. And Gross says, but what's going to happen when the German defense lawyers will object? And Maxwell Fyfe said, we will not allow them to object. Just as 227 did not produce the prosecution of the Kaiser, what it did produce is something on which, a few years later, one could build the notion of crimes against peace. Well, the same thing is true, as I'm sure you recall, on the notion of crimes against humanity, or at the time called crimes against the laws of humanity. The 1919 Commission, which was established to investigate those crimes, decided that the Turks were responsible for these crimes in reliance upon what text? There wasn't any text, but they fished out the word in the preamble of the 1907 Hague Convention. And it was an interesting philosophical concept about which several of you here, including Larry and David, wrote about. They fished out the concept that there is something that exists. It's not natural law, but there is something that exists that is called the laws of humanity. And until such time as we are able to agree on more of what the laws of humanity should include, this is what we have agreed upon in the 1907 Hague Convention. That, therefore, is not the beginning and the end of everything. This is an elastic document. Yes, we can stretch out. We have some elbow room. And you know what? If the same types of crimes were committed, but the difference is not between combatants of two different states, but between the troops of one country against its own citizens, then the stretch is not a big stretch, and we have something called crimes against humanity. Well, it just didn't work after World War I. But suddenly it became a precedent. It became a customary rule in the making. And the customary rule in the making evolved into the provisions of crimes against humanity in Article 6C. But the drafters were very careful to link 6C with 6A and 6B, and to a large extent it took us some time until we managed to decouple the commission of crimes against humanity from the context of either commission of aggression or commission of war crimes. That was, in my opinion, one of the reasons why that provision in the ICTY statute was included. I have to admit to you that I was the one who drafted it, and I made the case before the Secretariat of the UN that we needed to say that crimes against humanity were committed in connection with a conflict of an international or non-international character, because I really wasn't too sure of the legal significance of the 1950 International Law Commission report decoupling the two. But shortly thereafter, the problem was faced in Rwanda, where it was clearly an internal conflict, and then the big jump was made, and that nobody has ever thought of looking behind. Well, why am I saying that? I'm saying that because any type of an assessment of the Nuremberg legacy leaves us with a number of these and many other questions that you can list in a more rational way than I'm doing so at this time. But I think that probably one of the interesting observations is that the Nuremberg legacy represents not only our perception of what we would have liked it to be, but it represents our perception of what we want it to be for the future as well. So it's a projection of both our needs and our expectations. And as a projection of the needs and expectations, it doesn't really have to rely too much on facts. It's not really important for us to know if crimes against peace really existed, if the Kellogg-Briand Pact was really enough of a legal basis to consider that an international crime, if Article 227 was enough of a background for it, if crimes against humanity was sufficiently developed in customary international law, even though it was rejected just a few years earlier, or if the Bassiouni trials of 1923 were a sufficiently valid precedent to support the provisions of Article 16 and the next process. But there were some significant progress that was made in many ways. Harken back, if you will, to the first of all international criminal trials, the Prysock Trial in 1474, when the 26 representatives of the Holy Roman Empire sent different judges to try Peter von Hagenbach. Fascinating little detail of history there is Peter von Hagenbach was actually carrying out the orders of the Duke of Burgundy. It was the Duke of Burgundy who told him to sack Prysock and to kill people because they didn't want to pay the taxes. Interestingly, at the time, that defense was not allowed. He was not allowed to show a written instruction from the Duke of Burgundy to do that. He was tried for crimes against the laws of humanity and the laws of God. Very interesting labeling of it. And as he sought to present that, they said, in essence, very interestingly, that the defense of obedience to superior orders was not valid. But they said it for a completely different purpose than that rule became known at Nuremberg thereafter. They said it because they wanted to shield the Duke of Burgundy, one of them, from criminal responsibility, as opposed to the exact opposite policy that occurred over 500 years later. As we look at Nuremberg, it would seem to me that we can look at three different categories of assessment. The first is the institutional legacy. That is, the existence of a tribunal, its processes, how it worked as a judicial institution, in comparison to the judicial institutions that we know in what René David called les grandes familles du droit, the big families of law, the big legal tradition, whether it's the Romanist civilist tradition, the Germanic tradition, the common law tradition, the Islamic tradition, and the many mixed traditions that have developed. So how does the institution itself compare, A, with what existed in these different families of legal systems, and how does it compare with the expectations of what an inter-national, as opposed to an international, meaning a supranational institution would be? And in particular, its processes. Did its processes meet the very simple test of fairness that would be applied in any ordinary criminal court in these institutions? The second is the legal legacy, and there I would say the substantive legal development, the law of the tribunal, and what is exactly its progeny, what came out of it, what is it that we can attribute in terms of a paternity or maternity line descendant from it. And then the third is what I heard Larry and Leila speak about, and that is the moral ethical legacy. The power of a principle that corresponds to certain basic human values and expectations. What is its influence on legal developments? How does it become part of social consciousness? And then from there, you can take it on to a variety of other factors. Does it have an impact on prevention and deterrence? Does it have an impact on strengthening consciousness either through a process of memorialization or through the process that we are undertaking here in terms of conferences and intellectual input into this particular process. The judgment on each one of these and many of their subcategories will vary enormously. It's not going to be a uniform judgment. While you may find, for example, that the institutional legacy of the IMT in terms of its processes may be more satisfactory or less satisfactory, you obviously have to ask the question, more satisfactory or less satisfactory than what? Certainly compared to the almost simultaneous processes of the IMTFE, by far the IMT has a significantly advanced qualitative nature. If nothing else, the president of the tribunal was not particularly enamored with the bottle, and he didn't come at every afternoon session after lunch mostly drunk, mistreating the defense counsels and acting in an outrageous manner. The dignity with which the judges and the prosecutor behaved was very significant. But bear in mind also the difference in the cultural differences. The German defendants and the German people come from a very long and steep tradition of law and a respect for the majesty of the law. And even though they considered the tribunal to be illegitimate, their reverence and respect for the law was such that, if I can use an American term, they played the game. They were not particularly obstreperous defendant, except for Goering when he was on the stand, and you had to handle him, and he was able to take that and run with it for 3 days. But other than that, they were pretty well-behaved defendants. They played their roles as was expected, but that was because they came from that tradition. The Japanese, for all practical purposes, couldn't care less. They knew that this trial had nothing to do with law. This was designed to embarrass them. This was designed to make them feel bad. There was nothing worse for the Japanese than shame. These trials were for purposes of shame. Every one of the defendants would have preferred to commit harakiri, and that would have been an honorable end to prevent them from dying in an honorable way, to put them in a box to be tried by European sense of justice, which was absolutely absurd. And this buffoon of the president who comes in half drunk every day, that was the ultimate of shame to them. So they had absolutely no interest in it. Think of the differences that occurred. The differences were that the Germans continued the prosecutions of the Nazis for almost 50 years. Over 60,000 people were prosecuted by German courts. What happened in the Far East? By 1953, there wasn't a single person still in jail. By 1954, 2 of the major offenders in the Tokyo trials, one became prime minister and one became foreign minister. Imagine if any of the 22 persons who were tried at Nuremberg could have, 7-8 years after the end of the trial, become a prime minister or a minister of foreign affairs in Germany. Totally impossible. Did it have to do with Nuremberg and Tokyo, or did it have to do with the culture of the people? Obviously, in my judgment, in large part, the culture of the people. The Germans believed in the legal process. They adopted it. They made it their own. They pursued it. And they pursued their own local trials as well as administrative hearings. And they made it a social reality. The Japanese found out that this was totally alien to them, and they totally ostracized it. The procedures themselves really embodied, to a large extent, the common law procedures, and that was the beginning, in a sense, of a process, which I think we can see until now, of the hegemony of the American-type common law proceedings in terms of due process and fairness over all tribunals. As a student of comparative law, I'm not really sure that is the best thing. And frankly, when we deal with international
international institutions, whether it is from Nuremberg to the ICC today. I'm not really sure that a prosecutor is the best way to go. I think that the system of a judge of instruction is probably the best way to go. But the point is that in the course of time, we have simply accepted the adversary accusatorial process. How well is it working in Iraq? I know Mike Cherif will be addressing that later on in the conference. I don't think it's working well. And I think that it's not only a question of an obstreperous defendant or a defendant taking over the courtroom. I think what best serves the cause of justice, and I'm not sure that our model of adversary accusatorial justice serves it. Now, on the legal legacy, again, the legal legacy has been significantly, I want to use the word in a good way, manipulated. Yes, we have had a very significant outcome in the 1949 Geneva Conventions, but I'm not really sure that the ICRC came up with the 49 Conventions with an eye on what happened at Nuremberg. I think that they had an eye on what happened in the battlefield, and since most of their protagonists were military personnel, that's really what they looked at. So if you look at the contents, if you make a content analysis of the 1949 Geneva Conventions, you're going to find very few provisions that deal with the obligations to prosecute and how to prosecute and so on, as opposed to laying down the specific regulations and rules of combat that interest that professional category. So it was more a document that came out from and to a professional category. With respect to crimes against humanity, the ambivalence that existed then continues to exist today. We still do not have an international convention on crimes against humanity. We have 12 different definitions of crimes against humanity. Whether it's Article 6C or Article 5C and the IMPFE, the ICTY, ICTR, ICC, the International Law Commission, you go on and you try to tell me which is really customary international law. Only distinguished professors of international law know that. So the development of the law is also very interesting. Now, if you look at, for example, the whole legal legacy evolution, and you say, well, really, what has it spawned and what does it do? For example, you can say, well, I can look at the 1946 General Assembly resolution embodying the Nuremberg principles as a direct outcome. Yes, absolutely. Now, where is it today? What is its influence? Where do you see it? How many times do you see it cited? How about the 1950 International Law Commission report embodying the Nuremberg principles? When is the last time you saw that cited, let's say in an International Criminal Tribunal decision or anywhere else? The 1948 Genocide Convention, yes, we can certainly say that it's an outgrowth of that, but bear in mind, again, the history of that convention and the role of a single individual like Raphael Lemkin at the time, whose tenacity and hard work, and the strong constituency among Jewish victims of the Holocaust that brought this about. I'm not really sure that this is really the immediate progeny that we can ascribe without any further DNA to Nuremberg. I mentioned to you the 1949 Geneva Conventions. Look at the two drafts of the establishment of an international criminal court in 1951 and 53. But look at something maybe more telling. The 1968 UN Convention on the non-applicability of statutes of limitations to war crimes and crimes against humanity. And that is absolutely shocking in terms of the number of signatory states and number of ratifications to it. There is a counterpart European Convention, and there are only 5 of the European states that have ratified. Less than 60 countries have signed on to the UN Convention out of 192. Now, how is it possible that we would have such a strong principle established at Nuremberg, such as the non-applicability of statutes of limitations, not have a strong survival viewed through that particular process. I think the most important of the legacies is the moral ethical legacy. But it's also a limited one. It's limited to the Western experience. It's limited to Western civilization. It's not one that is prevalent in Asia, not one that is prevalent in Africa, not one that is prevalent in the Middle East. I think that what is quite significant, and here I would strongly suggest that maybe we don't really need to go through this process of assessment. Maybe we don't really need to look back at what actually is the Nuremberg legacy. Maybe it would be just enough for us to believe in the legacy, to accept it for what it is. Maybe there is nothing wrong in just give it the benefit of everything that happened since then. We have had worse hoaxes in history than that, and that would be a good one. Reinforcing something we believe in, something we want to, why not? And so I think there is really no difficulty in terms of a moral difficulty or an ethical difficulty. To look at the progress that we have had in the field of international criminal justice as being on the same continuum. And isn't it really on the same continuum? Isn't it really the call for justice as every human society understands it to be? And bear in mind one thing. If you look back at the 7,000 or so years of history of law, throughout 40 or so different civilizations, what is very significant is that there isn't a single civilization that did not have a legal system. Does that tell us something about the instinct of social survival and the need to have a law? Now, they were not necessarily always in favor of the individual or fully satisfactory of due process or achieving of justice as we would want it to be, but there's no doubt that law has always been part of our civilizations and our various societies. And as that is the case, why shouldn't we say that we need international criminal justice as part of the law of our society and of our civilization? It's difficult for us to say that in the age of globalization, we need to have complete freedom of movement of goods and money, but we don't need to have complete freedom of movement of fundamental human values of justice and of protection of human rights. If that is the case, and if we accept that premise, then why not accept Nuremberg as the basis of it and build upon it? After all, it is a way of reinforcing our social values. It is a way of reinforcing our beliefs. But in so doing, I think that we have to be extremely vigilant in terms of finding out that there are some things that we can achieve and some things that we cannot achieve. I will venture into hazardous ground here. Look at the ICC, the great expectation of the world community in terms of being an important step and an important component of post-conflict justice. And please note that I'm saying a component because I do not believe that post-conflict justice is limited to prosecuting everybody in sight. There are so many different multiple goals that relate to the sui generis nature of each and every conflict. And if we are to identify a goal, it is certainly not that of prosecution, but I would suggest to you would be that of reconciliation. And so to the extent that prosecution serves in reconciliation as a process, yes, it has to be used. But think of the practicalities of things. ICC is established. Security Council refers to it, the Sudan situation. Everybody is happy. And nobody thinks that because the Security Council refers the situation, it doesn't mean it's going to happen. And when the Security Council says, I'm not giving you a penny to do the work, you go ahead and do it. And you've got 102 state parties, of which half of them are developing countries, and 1/3 of them are less developing countries that can't even pay their dues. How are you going to get the resources to investigate? And this is the reality of things as those of us who have worked in the field have seen it. I've spent a year and a half battling the UN bureaucracy, which didn't want to give me a penny to do any field investigations. How do you manage to end run it? Well, sometimes you can. Sometimes you have somebody who says, you know what, I'm not going to be a politician as a prosecutor. I am not going to be in the hands of the United States. I'm not going to sign a secret agreement or a verbal agreement to say, whatever evidence you give me, I'm not going to use until you allow me to do that. I faced that issue as chairman of the commission. I was given a top secret security clearance and invited one day at the State Department and asked to sign an agreement in which I would be given all that information, but I couldn't use it without approval. And I said, sorry, goodbye. And I turned around and went back to Chicago. Sometimes you have to take a decision. There is, in my judgment, no two ways about it, and I regret to say that. There isn't, if I can make an analogy, and I hope you will all take it from the good side, you can't be a little bit pregnant. And you just can't be a little bit compromised. You either are or you aren't. And you have to make that choice from the beginning, and there are consequences to be paid. The ICC, if it doesn't have the resources, it doesn't have the political backing, what else does it have? Well, some of you who practice law will remember the old saying, that if you're in a case and the law is on your side, you pound the law, and if the facts are on your side, you pound the facts, and if nothing is on your side, well, you pound the table. I think that if you are in that position as an international prosecutor or investigator, you make up your mind. If the big powers are on your side, fine. If the big money is on your side, fine. And if nothing is on your side, well, try to drum up support among world public opinion. Maybe there's something there. Maybe there's an untapped resource that can back you up. Maybe the moral integrity of your cause is going to make it more difficult for those who want to undermine it to proceed. And I will conclude with something that has given me great pause to reflect on this subject, and particularly on the legacy of international criminal justice. And it's something that the French philosopher Pascal wrote, and he said, justice without force is important. Force without justice is tyrannical. Justice without force is infringed, because there is always the need. One must therefore combine justice and force, and therefore make strong what is right, and make right what is wrong.
Super.